Now on this P&ID issue, I won't bring guests, but I won't message them because I'm a busy man. I want to see if he will get time. If he will get time, enjoy me, because we will make even give us some sophisticated legal aspects of the thing, and I want also clear up some things we come out for one law journal today. In fact, I just go from start, because when I do this thing the last time, I made one error, really, just one error, and for me not be anything, because every other thing was fact. For the judgment, you know, and really, before I go on, the Nigerian lawyer, this publication. So today, make I give you the background. I don't know if I don't see this news. The Mr. Ayoride son, where I mentioned, he say he may sue me. He may sue me for defamation. He may sue me. Not be say he will. He may sue me. I want him to sue me. Honestly speaking, I want him to sue me. This kind of bullying doesn't work with me. When I'm bullied, I end up in court. I'm already in court for one. Because when you try to bully me, you also say I tough where. Many great men, greater than I, have stood on this platform I'm standing, and because of that, they kill them, they send them to jail, they destroy their life. Do you think I am better or more special than these people? For me to decide to not align with my class, I respect those that deserve respect only in my class. Nobody in Nigeria can say if the patient, if he tells you waiting to talk or waiting not to talk. The only way is if I respect you as a person, and the only way for me to respect you is that you are engaged yourself in national building as an elder, national development as an elder, and you comport yourself with the ethics and mannerism that is appropriate of an African elder. Anything short of that, you know, if you talk to me, but you won't follow me talk. Because Africa, would they say respect? You know, you must respect your elder for Africa. Yes, would they respect all those elders where they play the role of elder? That's what African tradition be. That's why we get the word agbaya. Agbaya, no, they collect respect. We have a word. That agbaya, what will be the meaning of agbaya for English? Nothing like that for English. What will be agbaya? That title, agbaya. We know say some agba. That the agbaya, segbe agbayi ma. So elder must be elder before that elder is ready. Must behave like elder, not be by age. All of that, they behave like elders. No, they behave like elders. And now I hope that young people are working in this Nigerian journal. Now this Nigerian lawyer will carry this case, this news now, because this man knows what he has done. He knows what I said he has done. I don't even come outside talk say not being leak paper. I've given him a win. I not do live. I just give him a win codedly. Make him just accept them. If his friends talk, he can show them say see he retracted it and just accept that win. But no, you have to go and publicize. You may sue. I don't print out the judge. I don't take the part of the judgment with the lawyer, with the judge. This not be me. So he must sue me and the British judge. When a master judge we talk, now I will go sue. So you may sue for defamation. MFM threatening me. One court. And Nigerian lawyers, you people should have read this judgment to yourselves. This is what we are saying. Nigerian, the journalists. I'm a musician, for Christ's sakes, and I'm not a lawyer. For the case, I should say every British lawyer in this world, when they involve in arbitration, we don't read this judgment by now. They would not read them in totality and entirety. Nigerian lawyers that club the day, or they bake cake on the weekends, they sew clothes, they do event planning on the weekend. All their spare time, they do TikTok dance, lawyer TikTok video. The most current and advanced rulings coming out from the world, you are not reading it. The one that concerns your country up to the tune of $11 billion. None of you have read it. None of you have come outside to say anything on the judgment. A judgment that it has come out on the Times in England. Opinion pieces has come out everywhere in the world based on this judgment. Unanko, what they do? Zero. Now, let me clarify again. The mistake I made in that thing is because now the address of the law firm now did the judgment. So I thought in that paragraph, that address, I thought the address was Mr. Ayonide's address. They said the papers were being leaked from 20 Marina Street, Apapa. And I went to investigate that 20 Marina Street is Shupo Shashore's office. Now, why I did not think it was Shukpo's office was because they also, Nigeria, this last case, also point at Shukpo as part of the saboteurs and ask the judge to indict him for the fraud. The judge say, based on the evidence before him, he no fit charge Shukpo with anything. Knowing fully well say, Mr. Shukpo get case for Nigeria for 100,000 fraud based on this case. He has to prove how something came out of his office without him knowing. But me, I thought that thing where the judge talk me say, you know, they involved. So I no come locate say na in office. So when I come say na in office be that, I now really understood what the judge meant. And my egbon I won't call come this live, Dele Ogun, he said na big arbitration lawyer and barrister for UK. He could explain to me say, based on the evidence before the judge, me say, not be the case where they talk be that. So you know if you talk about Mr. Shukpo case on this case, say the evidence on this case is not about Mr. Shukpo's fraud. So it's not really saying that he was not involved. He's just saying that he doesn't have the evidence here to talk about whether he's involved or not. Because also anything the judge could talk for that kind of case will affect Mr. Shukpo case for Nigeria. If they find him guilty on the offense already, or the judge make any proclamation on the case for UK, the prosecution will use it against him here in Nigeria. So the judge, the court too, did not want to bias his case. So anybody can make such an innocent error because my address not be named the right. Go and read the judgment. But now I will state clearly here, you know, and me too, I would like make a come explain how papers they fly out of your office. You don't know about it, you know. We would like to know. We would like to know. Anyway, I'll read. This is from paragraph 386. I'm not going to read all the other paragraphs where the judge they point to. But I'll read this part. If you want to follow him, you can read it in the judgment and follow those paragraphs to see what the judge said. Whether the case was not sabotaged. Because now what me I believe be that's my opinion. Because nobody go tell me say lawyer wey they charge $197 million. No go know the right question to ask. The judge said it here. I'll read what the judge has said. And I want to bring a lawyer, a fellow lawyer, to come and explain it to you people. May nobody come they bully me or with paper or newspaper say I may sue. Don't may. Man may anything. Not be person be Shukpo wey call me through the Mr. Shukpo wey call me try to get it, not be indirect, but they try to get in touch with me through back channels, and I respect that. But wetin be your own? You are too big because you don't collect $200 million. Abi? Let me say the judge's word. This not be Seun talk. The judge of the court for England. If Buhari not do anything for this country, Buhari say Baba. Buhari say Baba. Buhari say Baba. If you don't do anything for this country, say you don't pay this money, you are too much. So let me read. The moment I tell me that this not be sabotage. As before, it is not for me as a judge of the court to decide the merits of the dispute, where that task has been given to the distinguished and experienced tribunal. But again, in the present case, when I look at what was argued and what was not argued, I struggle to accept what happened in a dispute of this importance and magnitude. What does this line mean? He said that the judge is saying that for this kind case of 6.something billion, where they rise to 11 billion, he's surprised that our lawyer did not ask some certain questions that was there to be asked. He thought not be me surprised. This is the judge. He said, the judge, not be me, just say, I struggle. I quote, see, I'm quoting. I struggle to accept. Me, if Englishman can struggle to accept, me for Nigeria, I no accept. He doesn't take a struggle. I no accept. The British judge is struggling to accept. Me as a Nigerian, me accept. I struggle to accept what happened in a dispute of this importance and magnitude. This is even allowing for the fact that the tribunal was entitled to rely on the parties' professional legal representatives to take the point that their clients wish to take, and even accepting that the conduct and effort of the Nigerian government administration and lawyers at this quantum stage of the arbitration was deserving of severe criticism. Accepting that the conduct and effort of the Nigerian government administration and lawyers at this quantum stage of the arbitration was deserving of severe criticism. Let me tell you again, this is unprecedented. Deserving of severe criticism. Again, it is very clear. Now, this, before I continue, I was saying something. This judge, what he did here was unprecedented because he said never see this kind of nonsense before for his life. For him to be quoting things that had happened in the tribunal itself, in the arbitration tribunal itself. It was bringing out what was said there to say, how can a lawyer... Anyway, let me continue. You need sabotage. You didn't sabotage. You want to sue, you may sue. The only mistake I made is that your company leaked paper because the address, and now you know your address, and I've corrected it. Say, sorry, you didn't leak paper. That's not the address. Take your win, fam. Don't threaten me. Don't bully me. Don't. I always end up in court when I'm bullied. I always do. Again, it is very clear that the tribunal and P&ID had met with many inexcusable delays from Nigeria. Of course, it is understandable that the tribunal should manage the arbitration firmly in response. But at the quantum stage, these points, among others, illustrate how unsatisfactory things were. 1. Nigeria's expert witnesses upstream did not, in the view of the tribunal, appear to have been shown Mr. Michael Quinn's evidence. See 369 above. So all this one, I don't think go read that for now. Go and see it. Further, it was the fact known to the tribunal that, of course, the fault of Nigeria that upstream had very little time to prepare written reports in the case of this enormous possible damages award. But part of their function as independent experts was to assist the tribunal, and time must have compromised their ability to provide that assistance. 2, it was respectfully Oyibo Englishman. He said it was respectfully clear that Nigeria's leading counsel, Chief Ayanride SAN, did not understand what the tribunal was putting to him. This is not through any lack of clarity on the part of the tribunal. I repeat, it was respectfully, I might add, sir, clear that the Nigeria's leading counsel, Chief Ayanride SAN, did not understand what the tribunal was putting to him. This is not through any lack of clarity on the part of the tribunal. See 354, 356, 359, 360, and 363, 364 above. Baba no even understand what they talk there. And not because the tribunal did not speak clearly or explain well. Baba does not know what they do there. He's here, the judge said, and they got $200 million or a charge, you know, where you take back. They're still paying you small. They are paid you, I don't know. But you charge. Is here. We are going to get there. Because the judge that talker said, after this charge, is here. He's here. Emma to everything. I just lock out. Because maybe through this my own case, I can disclose the law of disclosure. I can get many more documents who will show Nigerians, and I don't think they spoil this country for a long time. You're going mama share anyhow. You can't be elders to your children. You want to just secure your own and yours, Not that we are all your children in this country that you should look after. Think about our future, build legacy, strengthen your profession. How can you be in a country as a big lawman that there's no justice? Your law firm, there's no justice in this country. The more lawyers that are created in the image of the ones they should be looking up to, the more injustice we have. The more courtroom, the more judges, the more injustice. Everywhere injustice. Leading the case for Nigeria, time and again, matters were not put by him to P&ID experts with major consequences on key issues, as the majority decision shows. See 373, 375, 376, 380, 384, 385, and paragraph 386 above. The air of unreality is compounded by a statement of fees appearing to bear the signature of Chief Ayanride SAN and billing Nigeria 200 million naira for quantum of damages hearing and $197.5 million now for negotiation of arbitral award. Ṣé 200 million naira yẹn ò tí tó yín? Ẹ já sọ ọ̀rọ̀ síbi tó tọ́ wà. Ẹ lọ ṣe nǹkan, wọ́n fi àwọn èèyàn fẹ́ jalè, because Yorùbá ni wá, ẹ já sọ Yorùbá, àwọn èèyàn fẹ́ jalè lọ́wọ́ wa, ẹ wá lọ jà fún wa. Ẹ dẹ̀ gba ẹ já 200 million naira kan. Ṣé ọ̀tí ẹ̀ tó fún gbogbo ọjà? Tẹ́ bá tẹ̀ fẹ́ lọ pààyàn fún wa bẹ̀. Ṣé kò tó fún gbogbo ọjà yẹn? Ẹ tún gba $197.5 million. Ẹ dẹ̀ ṣiṣẹ́ yẹn dáadáa. Eléyìí ò dáa. Ihun tí ò dáa ò dáa. Èmi kọ́ lè kọ́ lọ sue fún defamation. Èmi kọ́ lè kọ́ lọ sue. Torí tí ìlú yìí bá dáa, ó jẹ́ kí ọlọ́pàá ti kó gbogbo, ó lè kọ́ ọlọ́pàá ti kó everybody. Ẹ̀yin náà mọ̀ pé tó bá gbé ìlú tó dáa la wà, ọlọ́pàá ti kó everybody. But ìlú tá a wà ló jẹ́ kí ẹ máa sọ pé ẹ may sue me. And $197.5 million for negotiation of arbitral award. Even the judge say the air of unreality is compounded. After which he was the air of unreality was, that means the madness You know, understand? The heir, oh, this judge, is he Shakespeare's grandson or great-grandchild? We must investigate this judge. His literal capacity. I'm blown away here. I mean, rappers should come and read. Rappers need to come and read this judgment. He won't tell us it's a disgrace. What is what he Yahweh? When he keep when they say of us don't mad. They say the air of unreality. I don't read past the thing before I go back. This thing just hit me for the first time. See, this man just called all of us mad. The air of unreality is compounded by a statement of fees. The air of unreality is compounded. Is compounded. Say that one burst in brain. You don't understand? The man, they say that one burst in brain. Now, this is not even the worst part. I've not gotten to the worst criticism of the judge against this our lawyer. I've not gotten to the worst part. There does not seem, now number 3, there does not seem to have been argument and consideration of argument whether over 20 years profitability might deteriorate for reasons not concerned with Nigeria's compliance with its obligations. For example, a hardening adverse position for gas in the context of a developing global response to climate change. Or save perhaps at 395 above, which again contains points of law and fact that Nigeria did not test. Note also 372 above of the possibility that P&ID might at least in time have devoted profitability elsewhere, the time and energies it would have otherwise have had to devote here. This might test conventional legal opinion and be unsuccessful, but they were not attempted, where so much turned on it for both parties. The common law in relation to prospective loss after repudiation continues to be found or developed, see by way of relatively recent example, Flame SA versus Glory World Shipping in 2013, Lloyd's Rep 653. He gave cases reference as in what was made to an article by Professor Edwin Peel discussing that decision, but references. But it will be interesting to see what Professor Peel and Sir Najetier made of a case with the facts and circumstances of this present one. I don't have those cases here, but definitely you understand the concept, the context. For me, this was the worst one, that our lawyer did not even argue that you are charging us this money based on your 20 years profit. All the things that can happen in this world that is not Nigeria's fault, that will affect this profit. It's a simple argument. Me go where I not be lawyer, I swear down. In this climate change world, if I'm arguing a case with a company that's talking about gas business and you want to make money, I'll just tell you that think about your money well, battery operated, the world is going green. You understand? That even that simple, just say, even that simple argument was not made. So all this other reference was in other things that look like our own, that people even made more crazy arguments. That's why I say you would have loved to see what those people would have spoken about this case here that had all this mago involved again on top. Listen as Seun say. Number 4, interest. See 392 to 394 above was a point of very real importance. I repeat, Nigeria found its own unsuccessful argument on discount rate rebounding on it, rather than a closer analysis being pressed for. Billions of dollars will turn on this. There was no attempt to test the conventional idea of what P&ID would have had to pay to borrow the money or could have earned by investment in Nigeria. When dealing with sums so vast that in no real circumstance would P&ID be borrowing them or would have invested them in Nigeria. I can see the point 5 is even the worst one. In the background was the fact that P&ID estimate of his loss of profit at the commencement of the arbitration was 1.9 billion. The figure was 3 times higher by the time of the awards. Of course, these uplifts can happen, and the case is decided on the evidence, but the point adds to concern. Further, and although the tribunal was not to know, no one within the parties believed in a figure anywhere near 6 billion as the discussed settlements. The drop to 850 million was particularly rapid, above C399, I do not know whether those of these points that were known to the tribunal troubled the tribunal. I respectfully anticipate they would have. I repeat, I appreciate the views on what a tribunal should do in this situation would differ. Respectfully, I do not consider the tribunal did all that it could do to find out more about the point by question of Nigeria's legal representatives. But in any event, among the things the tribunal did not know and could not be expected to know was that the receipt and retention by P&ID of Nigeria's internal legal documents continued. So you see where the mistake came from, that all the things they talk for years since now about the man legal farm. So when he reached here, the legal leak continued. So me, I thought it was this firm, but it was another firm. That's the only mistake I made in my summary of this thing. That's the only mistake I made. And I called myself out. A one newspaper, Mesuyani. Take me to court. No May, take me to court. Let's sue ourselves. Let's get into the case. Let all Nigerians come and see how they are charging $200 million to not be able to ask simple questions, to not even be able to investigate profit and loss on behalf of your country, to not be able to investigate the deals and the discounts that they would have gotten from banks in terms of investments in the business, just accepting any figure that they threw at Nigeria. That you found your own unsuccessful arguments. Didn't even go through the conventional way. When they say Seun, they defame character. How did I defame? Let me live.
As I said, we lawyers are good at certain things, but when it comes to technology, we are intellectually challenged, or cerebrally challenged. But let me go back to my story. I laughed when I was hearing you talking about the offense of wandering. So this, I had been called to the English bar the year before, went to Nigeria for the Nigerian Law School. And a friend of mine and I, we're both English barristers now. We were coming back from a party. And we were walking. His place was in Stadium, and my place was in Alhaji Masha, just by the roundabout. And we were walking from Stadium up to mine. I think the party was in Adilabu or somewhere like that. So we were walking together. All of a sudden, we wanted to try and flag a lift, only for it to be a police car. And so they said to us, where are you going? And we said, look, we're going to a party around the corner. They said, there's no such thing as round the corner. This is Nigeria. They said, what do you do? Who are you? We said, we're students at the Nigerian bar. They just bundled us into the car, took us back to where we were coming from, Stadium, the police station by Stadium, took us to that station. And by the time we queued and we got to the front of the counter, as I now took the lead as a lead advocate to speak to the desk sergeant, to say, these guys, I turned around to point to the officers. They had disappeared. So anyway, by the time the desk sergeant realized that we were English barristers, he now released us, and we ended up catching Kabu Kabu back to where we're coming from. Anyway, so you brought back fond memories of the offense of wandering. It's real, people. It is real, real life experience. But let's go to this P&ID case. I need to give your listeners wider context. They need to understand the concept of arbitration. Arbitration is like a private court. You see, the regular courts, you can walk into any courts and sit there and listen to the evidence, to the arguments, to the judgment. Arbitration is special in the sense that it is confidential. And it's that confidentiality, that privacy, that secrecy that always attracted the big corporations when they behave badly. And they're always behaving badly. Arbitration is where you see it in the agreement. Any dispute between us will be resolved by arbitration. And the way it works is that each side chooses an arbitrator. And then the two arbitrators will then find a chairman. Now, in this particular case, because of the big bucks, the arbitrators were big players. These were English retired judges, this is what they typically go and do. They collect their pension. You know, they've reached the retirement age, collecting their pension, and then they're going for more. They're going for arbitration, sit as arbitrators. And the chairman in this particular case was a retired law lord, Lord Hoffman, one of the most technically brilliant amongst them in his days as a sitting judge. And so I was very interested. I've been following this case all the while. I'd actually written about it in my book, 50 Years a Briton, because I wanted our people to understand how arbitration works, how this arbitration system has been used to bleed us, and not just Nigeria, right across Africa. You hear of judgments right, left, and center, and it's arbitrated. You don't get to know the story. You only see the headline if it gets to the point that they now have to go and enforce it, which is what happened in this case. If we had paid up voluntarily, nobody would have heard anything about this case. And let me repeat that. Had it been that this story stopped at the point of the tribunal award against us, had it been $1 million or even $6 million that was awarded, this discussion wouldn't be happening. Nobody would have heard anything about this case. It's because the figure was so horrible, so huge, 6 billion. This is before the interest now took it up to 11 billion US dollars. That is when the case, let me be straight, it scared the arbitration system. And because Britain is a major player, London is a major seat of international arbitration, it scared them. They said, if this thing goes through, because it has now got to the publicity stage, you get to the publicity stage because of a challenge. You're challenging the award. And that's what we were seeking to do, to say this judgment is wrong. And they were blocking us. Those judges at the earlier stages that were dealing with our challenge argument were blocking us. But it now got to the level that we turned the arguments. We decided to play rough. And this is when it now came to the English courts, because you see that it was English lawyers who now took over, because our lawyers did not have rights of audience in the English courts. So the case effectively had to be handed over to UK law firms. And the judge said, is paragraph 14, he said, but this is a highly unusual case. Although one that draws attention to matters of wider importance, quite apart from the consequences for the parties, the matter touches the reputation of arbitration as a dispute resolution process. So you see, this case scared the living daylights out of them and said,
your accent is sophisticated. Let me explain to my people. What Bodile just said now is that our arbitration team did such a bad job and cunning job that they almost destroyed the entire process of arbitration. The arbitration got fair arbitration. Basically, by the time Nigeria's hand touch arbitration, we said the arbitration said, this is too much.
Oh dear, Nigeria. Let's just say we've made a contribution to international developments. Yeah, because this case ends arbitration as we know it. It does. It ends arbitration as we know, because the judge called it out. He said that, look, this is why he was reporting lawyers, reporting them to the Bar Standards Board, because the barrister in question was looking to collect 800 and something million pounds. And the figure that the judge himself had never collected in his lifetime on a single case.
Never seen that kind of money for a life. Another one was
and the
3 billion pounds.
solicitor was looking to collect 3 billion pounds. I mean, this is the mother of all arbitrations. This is the arbitration case that ends, completely radicalizes the whole arbitration, the practice of arbitration. Watch this space. Now, going back to, because I don't want to dominate your program, let me just say that your analysis of this judgment, the trouble that you've taken to read it, has shamed all lawyers, all Nigerian lawyers. Because as I'm listening to the trouble that you've taken as a musician to sit down with a 140-page judgment concerning oil and gas. These are technical issues. How many?
Not everything I understand. I will just use my
native intelligence.
At least I don't have to write essay on it. That's what I say to myself.
Native intelligence. I don't think people need to go to law school any longer. Just follow Seun to understand all your lectures in law. But there's one paragraph in the judgment that I'll take your attention to, which is along the lines of your theme, how this case was badly handled by the Nigerian team, not just the lawyers, right across the board. It's paragraph 305 of the judgment, where the judge said, the hearing saw no discussion of the question whether the law of contract today will treat this situation in a different way, to simply asking itself who asserted first that they accepted the other's failure as repudiation or repudiatory. Let me explain that to your listeners. Repudiation is a concept of contract law concerning breach. You can wait for an actual breach of contract, or you're entitled to say that the conduct of the other party to the contract is such that I'm entitled to treat him as saying he's not going to comply with his obligations. He's repudiating the contract. Maybe you want to break it down for your people.
Yeah. Meaning that who agree saying that Nigeria na fuck up? Why wasn't there an argument to say that we gone for Nigeria, we don't believe that this company, if we execute this contract with the consign, we have the manpower. They didn't have it. So who was to say who fuck up? Who agreed saying fuck up? Who agreed saying that them? Who was, I don't forget this paragraph, you're right. He jumped out at me too. Like, who even agreed saying that we fuck up? Who agreed this agreed? Say, okay, it's true, we our hands up.
So the judge said that there was scope for both parties to argue that the other had repudiated the contract, and it now becomes a race. So he went on and said, of course, Nigeria's side of that argument would face many challenges. But if ever there was a case where the economic consequences called for the most searching analysis, this was it. So he was saying that, break it down for your people.
This kind of, you go throw all points when you get the. You want they act of Wagbada, you want they fight like gentleman, you go push you, pull Agbada, like the judge they talk, but you don't even pull, you don't even lose your time. You don't even lose one button. You just they act normal. This judge, man, he likes Nigeria more than anybody that was in that Nigerian team. I don't even want to know what anybody said. This English judge is a Pan-Africanist. We should give him an award.
Yes, he was saying that this was a case that called for the most searching analysis, given the figures that were at stake, that we needed to go deep. We needed to go deep. And the point is this, that you see, law is not static. It's never static when it's practiced properly. There are cases like this where you use them to shift the boundaries of the law. So, okay, that's what was decided 5 years ago, 10 years ago. But this is now. And these are issues in this case. Things have changed, things have moved. These are the arguments, these are the facts that you've got to take into account. You can't just follow what has been decided before. So that's what the judge was saying. That searching analysis, this was a case, if ever there was a case that called for searching analysis of arguments, this was it.
Definitely. That kind of money, and well, anyway, how can there be searching analysis? There cannot be searching analysis when the judge said also let us that they understand because they didn't understand the question of the tribunal. They comprehend level of questioning. See, tribunal juice legal team our legal team they didn't understand it. So how can you at that basic level gone there's failure? So the investigative analysis part of the case can't exist. They are there to collect their check. You know, everybody is already made, everybody is already happy, everybody has won there. P&ID had won, the legal team of Nigeria had won. Nigeria lose. Our lawyers had won, P&ID had won, the tribunal judge had won, everybody had gone home. Only Nigerians constantly losing. Everybody had won because $197 million. That's a win for me. I don't care if they sentence my client to death. I have won the case. When I get home, I'm throwing party. I'll buy my wife a new car, buy my children cars. It will be as if we won the case. We won the case. $197 million. People are wicked. That's wickedness. That's not belief. That's wickedness. That is, I hate my country. That's the sign. I hate my country. Plus 200 million naira country. Wow.
Let me make this final comments about this case. The case saved us. It saved Nigeria. As I said before, it is Pan-African. It changed. I don't like Pan-Africanism. You know my views on that. I'm an Africanist, not a Pan-Africanist. Yeah, but this case saved Africa. It saved Africa. Why? Because, but for those errors in the errors and the misconduct in terms of the leaking of documents, privileged documents, that this judge highlighted, but for these events that allowed the arbitration system to be threatened so severely, things will have just gone on as normal. If those arguments that the judge is saying should have been taken or could have been taken, had been taken before the tribunal, you know what would have happened? The tribunal will have listened to those arguments and still decided against us. Are you following me? Because that's how the arbitration system works. You know, they will hear those arguments. The arguments that this judge is saying should have been taken by our legal team. Had they been advanced before the tribunal, that tribunal who was looking for a way to hand our money over to P&ID, that briefcase company, would have decided against us. But because they were not taken, so indirectly, the failures have helped us, because this is what's now exploded the whole case.
That's that gave us the chance for the new trial.
Exactly.
Because the competence was clearly shown.
In fact, there was a grammar that I think it was P&ID lawyers used that the judge quoted, and I'm looking for it. Paragraph 28. P&ID pointed to what it said was evidence, or what it termed catastrophic incompetence, both individual and institutional.
I see the judge said the air of unreality.
The air of unreality. There's real Shakespeare in this judgment. Everybody should read it.
Our life has now finally finished.
The air of unreality. Sharon, let me leave you to your audience.
I will thank you very much for giving us your time. I know you're a very busy man. We appreciate this time you've given us to share your knowledge and open our eyes to see things, from an intellectual point of view and a legal standpoint. Okay. I remember my booking, but knowledge I share. Good.